It's a medical malpractice trial, and now my medical expert is on the witness stand being cross-examined by the defense attorney. Can the defense attorney ask my medical expert what he and I spoke about before he took the witness stand? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. Now, let's say, for example, the defense attorney were to ask my client, the injured victim, about what he and I spoke about before my client took the witness stand at trial. The moment he says, "Tell us what you and your attorney talked about," I would be jumping up, yelling out, "Objection, Judge, that's privileged information." Which means that any communication that I have with my client is privileged and cannot be discovered by the defense attorney. So now, instead of my client, I now have my medical expert on the witness stand. And now the defense attorney wants to know what he and I spoke about. Can he ask my medical expert what it is that we talked about? The answer is yes, he can. And does my medical expert have to answer that question? The answer is yes, he does. Now, why is that different? It's different because I've hired a medical expert to come in to testify, to support our claim that we are more likely right than wrong, that what we are claiming is true. In a medical malpractice case, we need a medical expert to confirm that, number one, there was wrongdoing, number two, the wrongdoing caused injury, and number three, the injury is significant and or permanent. So now the defense attorney has an opportunity to do a detailed, thorough cross-examination. And he will ask what medical records I provided to my expert. Why does he want to do that? He wants to do that because he wants to see what information he used in order to come to his conclusions that his doctor, his client, departed from good and accepted medical care, causing my client injuries. He wants to see what information was provided to him. He wants to know what I told the doctor about what was going on in the case, about what testimony has already been given, about what the facts show, about what the evidence was, about what's contained in the medical records. So now, if I provided information that was inaccurate, now he has an opportunity to go after the doctor and to show to the jury that his opinions are not truly believable. Why? Because the information he was provided was not entirely accurate. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in this type of case here in the state of New York. You and I understand and I recognize you're watching this video because you likely have questions or concerns about your own particular problem. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.